thank you for joining us. My name is Jennifer Hopens. I am an Assistant General Counsel with DWC's Legal and Communications Services area.
Hello, I'm Jeff Carruthers. I'm the Regional Director for the Southern and Eastern regions within hearings.
And I'm Jerry Thomas. I'm the Director for the Northern and Western regions.
There's a lot to learn when it comes to dispute resolution, so we thought we would break this topic down by basic questions to bring needed perspective and assist in identifying key details. We will start with the 5 W's, often referred to as reporter's questions, commonly taught in journalism courses, then to how, and as a bonus at the end, a series of hypotheticals that might beg the following question. Huh? Here you can see a disclaimer. I refer you to the language in the slide and also the disclaimer prior to the beginning of the presentation. I also want to bring to your attention, because of occasional subtle differences inherent in the Texas Labor Code and agency rules, you may occasionally see an asterisk as part of these slides. We will explain why it is there. All right, let's start by identifying some of the key players in the Texas workers' compensation system with our first question, the who.
The who? Well, we are the Texas Department of Insurance Division of Workers' Compensation. Our commissioner is Commissioner Jeff Nelson, and we're the agency that administers workers' compensation in Texas.
So the hearings section with it is the program area within the Division of Workers' Compensation that oversees and administers the Workers' Compensation Dispute Resolution System, which is the system that resolves at the administrative level workers' compensation benefit disputes that arise between system participants. Most of these disputes are between injured employees and workers' compensation insurance carriers, although as we will discuss later, other types of system participants can be involved in these disputes. So why the asterisk on this slide? Well, that is because medical fee dispute resolution is overseen by a different program area, the Medical Fee Dispute Resolution section, under Director Greg Ardent, although those type of disputes may eventually proceed to a benefit review conference in the hearings section.
For our DWIC hearings overview, we have a Chief Administrative Law Judge, that's Alan Craddock. We have a hearings coordinator, that's Katie Kidd. Our dispute processing section is led by Director Tiffany Duarte, and she oversees the proceedings resolution officers, which are pros, docketing, and dispute processing staff. Then we have benefit review officer 1s and our presiding officers. Presiding officers are benefit review officers 2, 3, and our administrative law judges. Jeff Carruthers oversees the presiding officers in the southern and eastern regions, and that's San Antonio, Houston East, Houston West, Lufkin, Uvalde, Weslaco, Corpus Christi, Beaumont, Laredo, and Austin. And then I oversee the northern and western regions, and that's Dallas, Fort Worth, Denton, Waco, Tyler, Abilene, Midland, San Angelo, Lubbock, Amarillo, and El Paso, and also our benefit review officer 1s with the assistance of Miss Lori Reyna, and she's our benefit review officer 1 lead. And then Judge Christina Bassetto leads up the appeals panel. Next, we have our benefit review officers. At the administrative level, disputed claims proceed through a 3-step process. First is a benefit review conference, and then we have a contested case hearing, and finally an administrative appeal. If the parties cannot agree about a claim, the first thing they can do is ask for a benefit review conference. The process typically begins when a party files a DWIC 45, which is a form to request to schedule, reschedule, or cancel a benefit review conference. A benefit review conference is an informal meeting where the parties work with a benefit review officer to mediate the dispute. A benefit review officer is not required to be a licensed attorney, and the division has 3 different levels of benefit review officers. We have a benefit review officer 1, who is not a presiding officer, and they do not conduct benefit review conferences. If a case involves maximum medical improvement and impairment rating, they work with the parties before the benefit review conference to determine whether multiple certifications are needed from a designated doctor. A benefit review officer 2 presides over benefit review conferences and mediates disputed issues. And finally, we have our benefit review officer 3s. Those are our BRO leads, and they preside over benefit review conferences and mediate disputed issues. They also provide oversight and guidance to other benefit review officers.
So the next step in a workers' compensation dispute after a benefit review conference is the contested case hearing. The parties may proceed to such a hearing on issues that were raised and not resolved at the benefit review conference. So an administrative law judge will preside over the contested case hearing. The administrative law judge is required by statute to be an attorney licensed in the state of Texas. And the division does have administrative law judges in our field offices throughout the state. So at the contested case hearing, the administrative law judge will perform duties that include swearing in witnesses, receiving testimony, allowing the examination and cross-examination of witnesses, accepting documentary exhibits, and hearing arguments presented by the parties. So after the contested case hearing, the administrative law judge will issue a written decision that includes a determination of whether benefits are due.
So a party who's dissatisfied with the decision of the administrative law judge may appeal the decision to the appeals panel. And appeals panel judges are, like administrative law judges, required by statute to be attorneys licensed in the state of Texas. Unlike the ALJs, they do not hold a hearing. They are a reviewing body. In fact, the statute expressly forbids appeals panel judges from conducting benefit review conferences or contested case hearings.
The division appoints a designated doctor to resolve disputes on specific issues. Under Texas Labor Code Section 408.0041E, the designated doctor's report is given presumptive weight unless it's overcome by preponderance of the evidence. Designated doctors must meet the qualification standards under 28 Texas Administrative Code Section 127.130 and may be disqualified under certain circumstances. A designated doctor may be appointed through a DWIC 32, which is a form filed by a party, and it's for a designated doctor examination. Or a designated doctor can be appointed through a presiding officer's directive, which is a POD issued by a benefit review officer or an administrative law judge. Under Texas Labor Code Section 408.0041, the commissioner may order an examination to resolve questions such as the impairment caused by the compensable injury, attainment of maximum medical improvement, the extent of the compensable injury, whether disability is a direct result of the work-related injury, the employee's ability to return to work, or other similar issues such as lifetime income benefits.
So, who are the parties in dispute resolution? First, we have injured employees. The injured employee is generally seeking income or medical benefits, or even both of those type of benefits. Next, we have legal beneficiaries can be in dispute resolution. Generally, this is a person who is seeking entitlement to death benefits under the Texas Workers' Compensation Act following a death of an employee resulting or claiming to have resulted from a compensable injury. Sometimes the compensability of the employee's death is not in dispute, but the beneficiary's status as a proper legal beneficiary of the deceased is in dispute. Next, we have insurance carriers. This is generally an entity that issues a policy covering compensation for workplace injuries and deaths for an employer. This may also include a governmental entity that self-insures either individually or collectively. Next, we have the employer. This is the entity for whom the injured employee worked at the time of the injury or alleged injury event. So why the asterisk next to employer? Well, this is because employers are only parties to dispute resolution in the limited circumstance where there is a dispute over the compensability of the overall injury and the insurance carrier has accepted liability for that injury. In that circumstance, the employer may seek dispute resolution to contest the compensability of the injury. And then lastly, we have subclaimants. This is typically healthcare providers or other entities who have sought and been refused reimbursement for compensation, including healthcare provided by a healthcare insurer, directly or indirectly to or for the employee. Often these entities are seeking final adjudication of compensability for the injury so that they know who to bill.
So now we'll get into some core substantive information relevant to dispute resolution. The what?
So what brings the parties to dispute resolution? Well, typically the starting point is an injury that has or is alleged to have occurred in the course and scope of the employee's employment, and a disagreement about that injury that necessitates resolution through the division's dispute resolution process. So the most common type of dispute we see in hearings are benefit disputes. And we do have a definition of benefit dispute, and that is a disputed issue arising under the Texas Workers' Compensation Act and a workers' compensation claim regarding compensability or eligibility for or the amount of income or death benefits. So just one example of how a dispute may be started would be an injured employee who requests a benefit review conference after receiving a PLN-1 or PLN-11 from the insurance carrier. The PLN-1 is the notice used by the insurance carrier to notify the injured employee and the division of the insurance carrier's denial of compensability or liability for an injury. The PLN-11 is the notice used by the insurance carrier to notify the injured employee or beneficiary and the division of the insurance carrier's dispute of an issue such as disability, extent of injury, or death benefits. With every PLN, there needs to be an explanation of the reason or reasons for the dispute in plain language without unnecessary use of technical terms, acronyms, and/or abbreviations. Other than benefit disputes, there are a few other types of disputes that go through our dispute resolution system. Number one, we have disputes of certain official actions taken by the division. These will be disputes of an official action taken by the division where there is a rule that allows such a dispute to be brought. The most common type of these disputes that we see is a dispute of the division's approval or denial of a party's request for a designated doctor examination submitted on a DWIC 32. Another example is a dispute of the division's approval or denial of an attorney fee. Next, we have medical fee disputes. Those disputes start in the MFDR section. And then if a party is dissatisfied with the decision there, then they can come to hearings and request a BRC. And then if the dispute is not resolved at the BRC, then the next step in dispute resolution is to a contested case hearing before the State Office of Administrative Hearings. We also have disputes of an independent review organization decision on the medical necessity of health care. If any party is dissatisfied with the decision of an IRO, they may request a contested case hearing with an administrative law judge at the division. Those contested case hearings will be conducted as any other contested case hearing is held. The judge, the ALJ, will issue a decision, and then after that, the next step in the appeal is to a district court. The statute and rules governing dispute resolution can be found in Texas Labor Code, Chapter 410, and 28 Texas Administrative Code, Chapters 140 through 147.
What are our common types of benefit dispute issues? Well, we have existence of the compensable injury, compensability of an occupational disease, date of injury, timely reporting of an injury to an employer, extent of injury, intoxication, disability, maximum medical improvement, impairment rating, 90-day finality, and supplemental income benefits. It is critical for parties litigating these cases to understand the issues and the applicable burden of proof. This is not an exhaustive list. For example, it does not include such issues as reimbursement of travel expenses, change of treating doctor, lifetime income benefits, average weekly wage, medical fee disputes, or medical necessity disputes. 28 Texas Administrative Code Section 133.305 provides general information regarding medical dispute resolution, which is the process used to resolve medical fee disputes and medical necessity disputes.
Let us now travel across the universe of DWC dispute resolution and beyond. The where.
Well, we have our administrative process, which are benefit review conferences, abbreviated as BRCs, our contested case hearing, abbreviated as a CCH, our appeals to the appeals panel, and they're the AP. And if you're dissatisfied with your administrative process and you've exhausted your administrative remedies, then you can appeal a case for judicial review, and that's filing a petition with a district court. Where does dispute resolution begin, and why do we have an asterisk? Well, dispute resolution can begin with that DWIC 45, but it can also be initiated by that DWIC 45M for medical fee disputes, a DWIC 49 for medical necessity disputes, or the parties can just request to proceed directly to a contested case hearing, often referred to as an expedited hearing. So during a benefit review conference, the injured employee, along with their attorney or ombudsman, meets with a representative from the insurance carrier and a benefit review officer to mediate the dispute. The employer, again, is not required to attend unless they file the dispute. Texas Labor Code Section 410.021 explains that a benefit review conference is a non-adversarial, informal proceeding designed to explain the rights of the parties and the procedures necessary to protect those rights, discuss the facts of the claim, review available information, and identify the disputed issues, and then mediate and resolve the disputed issues by agreement of the parties. Benefit review conferences are conducted by Zoom unless good cause exists for an in-person setting, and there is no record made during a benefit review conference. If the parties reach an agreement, the benefit review officer will assist them in drafting a DWIC-20 form, which is a form called a benefit dispute agreement. If no agreement is reached, the benefit review officer issues a benefit review conference report, and the case proceeds to a contested case hearing before an administrative law judge with the division. The report establishes the issues the administrative law judge will consider at the contested case hearing. And that's under Texas Labor Code Sections 410.031 and 410.151B. Each certified issue also includes a summary of the party's position on that issue, and a benefit review officer may issue a scheduling order outlining the actions the parties intend to take on the case, for example, obtaining a causation letter. An administrative law judge may consider compliance with that scheduling order when ruling on a motion for continuance, because continuances can only be granted on a showing of good cause under Texas Labor Code Section 410.155. Where do we exchange this information for the benefit review conference? Well, you can exchange it with the other parties by mail, or you can send it electronically if the other party has a fax number or an email address. To exchange the information with the division, you can send an email to brcexchanges@tdi.texas.gov, and there's an underscore between BRC and exchanges. You can fax it to 512-804-4011. You can mail it to our P.O. Box. You can also use our secure file transfer protocol.
As stated, the administrative law judge will preside over the contested case hearing. A contested case hearing is a formal adversarial proceeding that is like a non-jury or bench trial in that the parties present evidence and make arguments to the ALJ on the disputed issues. The purpose of the hearing is to fully develop the case and inform the ALJ so the ALJ can make a decision based on all the facts to resolve a benefit dispute. So the disputed issues at the contested case hearing will be those issues that are identified as unresolved in the benefit review conference report that was issued by the benefit review officer after the BRC. The statement of disputes can also include any responses to the BRC report presented by a party after the BRC, as well as any additional disputes added after the BRC in accordance with applicable rules. So the typical types of evidence we see presented at a contested case hearing includes witness testimony under oath, expert medical causation opinions both in writing and by testimony, designated doctor reports on issues such as extent of injury, maximum medical improvement, and impairment rating, certifications of maximum medical improvement and impairment rating from other authorized doctors such as treating doctors, referral doctors, and required medical examination doctors. We also see in evidence peer review reports as well as medical records. So after the contested case hearing, the ALJ will consider all the evidence and arguments presented by the parties about the disputed issues and then file a written decision with the division within 10 days after the close of the hearing. The division will then mail the decision to the parties. The decision is effective and binding on the date signed by the administrative law judge. Contested case hearings by default are conducted in person at a division field office. Unless the division determines that good cause exists for the selection of a different location, the contested case hearing may not be conducted at a site more than 75 miles from the claimant's residence at the time of the injury. Recent legislative changes effective for contested case hearings requested on or after June 20th, 2025, allow for a contested case hearing to be conducted by video conference, either on the mutual agreement of the parties or on a determination by the division that good cause exists for conducting the hearing in that manner. So as far as how to file exhibits with the division prior to the contested case hearing, this slide lists the different ways to do so and are similar to how to file exchanges with the division for a BRC. The parties may file their exhibits by email at cch_exhibits@tdi.texas.gov. The parties may file their exhibits by fax or mail, or lastly, secured file transfer protocol.
So as touched on earlier, the appeals panel is a reviewing body, and the appeals panel judges will consider the record developed at the contested case hearing and the written request for appeal and response filed with the appeals panel. And this is found at Texas Labor Code section 410.203A. Under subsection B of that same section, the appeals panel may issue a written decision reaching a new decision, which is also known as reversing and rendering the administrative law judge's decision. They may send the administrative law judge's decision back to the administrative law judge for more action. This is also known as a reversal and remand. Or in certain circumstances, under Labor Code section 410.204A-1, the appeals panel may issue a decision leaving the administrative law judge's decision in place, that is, affirming the decision, and a written decision in that circumstance may be necessary to explain a recent change in the law, for a case of first impression, or in a case that involves errors that require correction but do not change the outcome of the hearing. Now, if the appeals panel does not write a decision in a case, they issue a determination letter notifying the parties that a written decision was not issued, and the decision of the administrative law judge is now the decision of the appeals panel and is the final decision of the division in the case. This is under Labor Code section 410.204C, and that letter is sometimes referred to as a final letter. So the appeals panel process is very time sensitive. Under Labor Code section 410.204A, a written decision must be issued within 45 days after the date the response to the request for appeal is filed, or if a response is not filed, the due date for that response. And the appeals panel is also responsible statutorily for issuing and maintaining the appeals panel decision manual, and this is under Labor Code section 410.203E. The appeals panel uses the manual as a guide in deciding appeals. The manual helps the appeals panel to achieve consistency in its decisions and to inform its customers of the legal principles it expects to follow in deciding appeals. As with all things legal, there is a disclaimer. Use of this manual is not intended to be a substitute for obtaining legal counsel or advice. So for most disputes in the administrative dispute resolution process for workers' compensation in Texas, the appeals panel is the last step. Why the asterisk? Well, there are certain disputes, and we've already gone through them. These are the medical fee dispute and medical necessity dispute tracks. We're not going to go into that again, but just know that those follow a different path than the disputed issues that we've discussed. So let's say you're not happy with the appeals panel decision. If a party is not satisfied with the outcome of the case after the appeals panel has issued its decision or final determination letter or final letter, then that party may take the case to court. And that party must file suit not later than the 45th day after the date on which the division mailed the party the appeals panel decision. And this is under Labor Code section 410.252. And then for purposes of this section, the mailing date is considered to be the 5th day after the date the decision of the appeals panel was filed with the division. Under Labor Code section 410.253A, a party seeking judicial review shall simultaneously file a copy of the party's petition with the court, serve any opposing party to the suit, and provide a copy of the party's petition to the division. Under Labor Code section 410.258A, if you've taken a workers' compensation dispute, such as the ones we've discussed so far, to court, you must file any proposed judgment or settlement, including a proposed default judgment or proposed agreed judgment, with the division not later than the 30th day before the date on which the court is scheduled to enter the judgment or approve the settlement. And there are consequences for noncompliance of this requirement. Under Labor Code Section 410.258F, a judgment entered or settlement approved without complying with the requirements of this section is void. Now we get into the when, and as you might guess, the key things to keep in mind are that many components of workers' compensation dispute resolution are time critical and tied to deadlines. I would note that this is a non-exhaustive list of deadlines. For the sake of time, we wanted to keep things relatively simple. Let's begin with the dispute over the finality of the first valid certification of maximum medical improvement, MMI, and impairment rating, IR. So the person challenging the finality of that certification has 90 days from the date on which the certification is provided by verifiable means to file a dispute of that certification. Otherwise, that certification becomes final. Let's break this down into two distinct paths, depending on whether a designated doctor has been appointed on the claim. If a designated doctor has not been appointed to address maximum medical improvement and impairment rating, a certification of maximum medical improvement and impairment rating may be disputed by filing a DWC Form 45, that's the request for a benefit review conference, or by filing a DWIC Form 32 to request the appointment of a designated doctor. If a designated doctor has already been appointed to address maximum medical improvement and impairment rating, the party must dispute the first valid certification by requesting a benefit review conference and filing a DWIC Form 45. And this is in accordance with 28 Texas Administrative Code Section 141.1. Now let's talk about supplemental income benefits, or SIBs. What if the insurance carrier wants to dispute an injured employee's application for supplemental income benefits? I break this down into two distinct paths as well. Let's start with the first quarter of SIBs and secondly, the subsequent quarters. For the first quarter, the division makes the determination of entitlement to the first quarter, and an insurance carrier has 10 days to dispute DWC's finding of entitlement. DWC decides entitlement for the first quarter and first quarter only. An insurance carrier waives the right to contest the division's determination of entitlement to or amount of supplemental income benefits for the first quarter if the request, the DWC Form 45, is not received by the division within 10 days after the date the carrier received the determination. For the subsequent quarters, the insurance carrier makes the determination, not DWC. So does the insurance carrier have to request a benefit review conference every time it denies entitlement to SIBs or risk waiver? The answer, that all too frustrating lawyerly answer, it depends. So if the insurance carrier paid the prior quarter, I refer you to 28 Texas Administrative Code Section 130.108C. If an insurance carrier disputes an injured employee's entitlement to a subsequent quarter, and the insurance carrier has paid supplemental income benefits during the quarter immediately preceding the quarter for which the application for SIBs is filed, the carrier must dispute entitlement to the subsequent quarter by requesting a benefit review conference within 10 days after receiving the application for SIBs, or the carrier waives into that quarter. Now, what if the insurance carrier did not pay the prior quarter of SIBs? Then the insurance carrier may not have to request a benefit review conference within 10 days, but the insurance carrier must send the determination to the injured employee within 10 days of the date the application was filed with the insurance carrier. I must add a caveat, however. There is appeals panel precedent standing for the proposition that when a prior quarter has not been paid at the time the insurance carrier has received the application for the subsequent quarter, but that prior quarter is actively under dispute, I refer you to Appeals Panel Decision 032868-S. Incidentally, if you see S attached to an Appeals Panel decision, that means it has been designated as a significant decision. So under that decision, where the immediately preceding quarter is actively under dispute, for example, there's ongoing or pending dispute resolution, such as a benefit review conference, contested case hearing, or appeals panel review, at the time the carrier receives the SIBS application for the subsequent quarter. The insurance carrier must file a DWC 45 to request a benefit review conference. This is even if the carrier did not pay the prior quarter, or the carrier waives into that subsequent SIBS quarter. Moving on to a change of treating doctor in a non-network claim, a party must contest this change within 10 days of receipt of the division order. This is found at 28 Texas Administrative Code Section 126.9G. The issue will then go through the DWC dispute resolution process we went over earlier, the benefit review conference, contested case hearing, and review by the appeals panel. For extension of maximum medical improvement for spinal surgery, an injured employee or insurance carrier may dispute the approval, denial, or length of the extension granted by division order by filing a request for a benefit review conference no later than 10 days after the date the order is received. For this issue, I refer you to 28 Texas Administrative Code Section 126.11G.
All right, and to add to the deadlines, we have specific deadlines relating to benefit review conferences. First, we have deadlines associated with sending and exchanging pertinent information. Pertinent information means all information relevant to resolving the disputed issues, and that's under 28 Texas Administrative Code Section 141.4. First, all pertinent information must be sent to the opposing party before requesting the benefit review conference. So that's your first deadline. Second, the opposing party must send any additional pertinent information within 10 working days of receiving the request. And then finally, the third deadline is no later than 14 days before the benefit review conference. The parties must send to the division all pertinent information not previously provided and exchange all remaining pertinent information with the other parties. That 14 days is cut down to 5 days if it turns out to be an expedited benefit review conference. Next, we have deadlines associated with requests to reschedule or cancel a benefit review conference. Under 28 Texas Administrative Code Section 141.2, the division may cancel or reschedule a benefit review conference in certain circumstances. That could be on the division's own motion, upon request from certain parties, or the mutual request of the parties. Parties can use a DWIC 45 or a DWIC 45M to request to cancel or reschedule a benefit review conference. And a request to cancel or reschedule a benefit review conference must be made within 10 days after the date the notice of setting is received. The very first request to reschedule a benefit review conference does not require a showing of good cause if it's received in that 10-day period. However, any subsequent requests or any requests made outside of that 10-day period must demonstrate good cause. And according to Texas Labor Code Section 410.026, a benefit review officer may schedule a maximum of 2 benefit review conferences on a dispute. That's our 2 BRC rule. Finally, there's deadlines associated with responding to the benefit review conference report. The parties can file a response to the BRC or the benefit review conference report if they disagree with it. And you can disagree with your position as noted in the benefit review conference report, or you could determine that you want additional disputes or issues added. If you want to submit a response to correct a party's position, that has to be sent to the division no later than 20 days after receipt of the report. If you want to add an additional dispute, think of it 2 ways. If everybody agrees, unanimous consent or agreement of the parties, then you can just file a request within 10 days before the hearing, or no later than 10 days before the hearing. The other alternative, if only one side agrees, so you don't have unanimous consent of the parties to add an issue, then you can ask for permission from the administrative law judge. And you have to demonstrate good cause, and that request has to be sent to the division no later than 15 days before the hearing. And that's outlined in 28 Texas Administrative Code Section 142.7.
So now, as far as some deadlines that apply to contested case hearings, we first have the deadlines for when the contested case hearing will be scheduled. The division will schedule a contested case hearing to be held not later than the 60th day after the date of the benefit review conference if the disputed issues are not resolved at the benefit review conference. However, if the division determines that an expedited contested case hearing is appropriate, then the division will schedule the hearing to be held not later than the 30th day after the benefit review conference. Now, there are limited cases where a contested case hearing may be scheduled without a prior benefit review conference. In these cases, the contested case hearing will be scheduled to be held no later than the 60th day after the date the division receives the request for the contested case hearing, or if the contested case hearing is to be expedited, the division will schedule the hearing to be held not later than the 30th day after the date the division received the request for the hearing. So the parties should be very diligent and mindful of the exchange deadlines for documentary evidence after the BRC. So why are these exchange deadlines important? Well, they promote fairness by averting unfair surprise. Also, the failure to comply with the exchange deadline may result in the exclusion of evidence that was not timely exchanged. What is that deadline? Well, except for an expedited contested case hearing or a dispute without a prior BRC, no later than the 15th day after the date of the BRC, the parties must exchange with one another the following information: all medical reports and reports of expert witnesses who will testify at the hearing, all medical records, any witness statements, the identity and location of any witness known to have knowledge of relevant facts, and all photographs or other documents which a party intends to offer into evidence at the hearing. Thereafter, the parties shall exchange additional documentary evidence as it becomes available. So the most common type of objection to the admissibility of evidence that we see at contested case hearings are objections based on the late exchange of documentary evidence. In these cases, the administrative law judge will base determination on admissibility on whether good cause existed for the failure to timely exchange the information. So again, it is very important to be mindful and diligent in exchanging your evidence with the opposing parties in a timely manner. So for the expedited hearings and hearings without a prior benefit review conference, the notice of the hearing will include the time limits for completion of discovery. So as for continuances of a contested case hearing, continuance means postponing a hearing from the time or date set and rescheduling it on a later time or date. So some points to be made about the continuance of a contested case hearing. The division may continue a hearing on its own motion or at the request of a party if the administrative law judge determines the party has good cause. So for a continuance that is made before the hearing, the request must be in writing. It must state the reason for continuing the hearing. It must include a certificate of conference that states that the movement has made reasonable efforts to confer with the opposing party about the request. Now, if the movement was able to confer with the other side, the motion must also state whether the opposing party objects to the continuance. And it must also propose a date and time for the rescheduled hearing that has been coordinated with the hearing's docketing section. So the motion must be sent to the division no later than 5 days before the hearing, and it must also be delivered to all parties. So the one exception to these particular rules are pro se claimants. A claimant who is neither represented by an attorney nor assisted by an ombudsman with the Office of Injured Employee Counsel may request a continuance before a hearing by contacting the division in any manner. So a party may also request a continuance at the hearing. In addition to showing good cause, the party must show that the continuance will not prejudice the rights of the other parties. So after receiving a request for a continuance, the administrative law judge will rule on the request and notify the parties of the ruling.
So under 28 Texas Administrative Code Section 142.16E, a decision is effective and binding on the date signed by the administrative law judge unless superseded by an interlocutory order contained in the decision, if there is such an order. Under Texas Administrative Code Section 142.16F, a decision regarding benefits not appealed to the appeals panel, as provided by Texas Labor Code Section 410.202 and Chapter 143 of this title, becomes final on the 16th day after the date received from the Division of Hearings. Now, let's say you do want to appeal the administrative law judge's decision. Let's discuss appeals and responses to those appeals. First, The appeal must be in writing and clearly and concisely rebut each issue in the administrative law judge's decision that the appealing party wants reviewed, and state the relief the appealing party wants granted. So a party has 15 days to file an appeal under Labor Code Section 410.202A. The start date for the 15-day period is for mailing 5 days after the date the administrative law judge's decision was mailed by United States Postal Service regular mail, the date the decision was faxed or electronically sent, and this last one pertains to insurance carriers only, the first working day after the date the decision was placed in a carrier's Austin representative box. You must also serve a copy of the appeal on the other party. Under Section 410.202B of the Labor Code, the response to the appeal must be filed with the appeals panel no later than 15 days after the date the copy of the request for appeal was served. So the response must be in writing and clearly and concisely support each issue in the administrative law judge's decision that the appealing party has rebutted in its request. And the response must state why the appealing party's relief should not be granted. So as with the appeal, you must also serve a copy of the response on the other party. Please note that the 15-day appeal and response periods do not include Saturdays, Sundays, or holidays listed in Texas Government Code Section 662.003. And please note, very important, the appeals panel will not consider a late appeal or response. So what is the driver, the purpose, the goal of our dispute resolution process? The why. So the answer to that question may be found in our agency mission: to regulate Texas workers' compensation efficiently, educate system participants, and achieve a balanced system in which everyone is treated fairly, with dignity and respect. So to truly understand the why of DWC, I encourage you all to read Labor Code Section 402.021, which provides the goals and legislative intent for our agency. We don't have time to get into every detail of that particular section, which is quite lengthy, but I wanted to highlight a couple of key points from that section. At 402.021A2 of the Labor Code, among the basic goals of the workers' compensation system of Texas is that each injured employee shall have access to a fair and accessible dispute resolution process. And under subsection B5 of that same section, it is the intent of the legislature that in implementing the goals described by subsection A, the workers' compensation system of the state must minimize the likelihood of disputes and resolve them promptly and fairly when identified. So we've explored the 5 W's. At this point, you may be thinking about best practices for navigating your path to successful dispute resolution. Now we arrive at the how.
Well, how? First, be ready and be prepared. A party or its representative commits an administrative violation if they attend a dispute resolution proceeding without full authority to settle or fail to exercise that authority to effectuate an agreement. And you can look at Texas Labor Code Sections 415.001 and 415.002 for guidance.
And just a few points to make about pre-contested case hearing preparation. If necessary, send your interrogatories or requests for subpoenas in a timely manner. Also, timely exchange your exhibits and witness lists with the opposing party. As I stated earlier, the failure to timely exchange evidence may result in the exclusion of that evidence by the administrative law judge. Also, please file your exhibits with the division before the hearing. We recommend that you file your exhibits with the division at least 3 days before the hearing. And also, ensure your exhibits are organized and in a proper order.
So we conclude our presentation with one last question, often asked in a state of confusion or bewilderment. Sometimes you're reading something and you wonder to yourself, did I read that right? Here are a series of hypotheticals that might make you scratch your head and ask, huh?
Okay, Jerry, the first hypothetical. I have received the BRC report, but it appears that the benefit review officer misstated my position on the issues. What do I do?
Well, it's easy. All you have to do is file a response to the BRC report and send it to the division no later than 20 days after receiving the benefit review conference report. All right, Jennifer, after reading the designated doctor's report, I noticed that he does not address 3 disputed conditions as part of his extent of injury opinion. He was asked to address the compensability of those 3 conditions in the presiding officer's directive after the contested case hearing. What do I do?
Well, a best practice would be to bring this to the administrative law judge's attention so that a letter of clarification, or LOC, may be issued to the designated doctor. Really, the key point here is that a letter of clarification is appropriate for a circumstance such as this, where the doctor has erred in some way. For instance, in this case, he was asked to address certain conditions, but he did not do so. Okay, Director Carruthers. The insurance carrier attorney has requested that the contested case hearing be held by video conference. I want it to be in person.
A contested case hearing may be conducted by video conference, either on the mutual agreement of the parties or on a determination by the division that good cause exists for conducting the hearing in that manner. So obviously in this hypothetical, the parties do not agree to conduct the hearing by video conference, so the hearing cannot be conducted by video conference on that ground. In this case, the insurance company, the insurance carrier would need to request that the hearing be conducted by video conference and convince the division that good cause exists to conduct the hearing in that manner. All right, Jerry, the last hypothetical. I just received my treating doctor's certification that I have reached maximum medical improvement on the date of injury with no permanent impairment, and I want to challenge this certification. No designated doctor has been appointed on the issues of maximum medical improvement or impairment rating.
All right, well, we began with an asterisk and now we're going to end with one because there is more than one correct answer in this situation. So in this case, since a designated doctor has not been appointed to address maximum medical improvement and impairment rating, the certification can only be disputed in one of 2 ways. You can file a DWIC 45, which is a request to schedule a benefit review conference, or you can file a DWIC 32 and request the appointment of a designated doctor. So 2 ways to dispute that certification, but keep in mind that the dispute must be initiated before the expiration of the 90-day finality period, and that's under 28 Texas Administrative Code section 130.12b, and a very important appeals panel decision 180848S. Again, if a designated doctor had already been appointed on this case, which is not your situation, Jeff, but if they had already been appointed, you only have one avenue to dispute that certification, and that's to file a DWIC 45 or a request for a benefit review conference in accordance with 28 Texas Administrative Code section 141.1.
Thank you for your time and attention today. Please stay tuned for the live Q&A. Hello, everyone. Thank you for attending today's CompCourses webinar. I hope you enjoyed learning about dispute resolution. Just as a reminder, you must stay for the Q&A to receive continuing education credit. So we'll begin with questions from the Q&A tab. Please enter your questions into the tab, and we'll try to get to everyone's question. The first one, does TDI, DWC, use mediators in a dispute? I believe Judge Carruthers, you're going to take that one. And you're muted. I should say Director Carruthers.
Sorry about that. Yes, the division does use mediators in our disputes. The division employs benefit review officers, and our benefit review officers will preside over the benefit review conferences, and they will attempt to mediate the dispute and attempt to move the parties to an agreement on whatever the disputed issues are. And if they are unable to do so, then the case might proceed to a contested case hearing. So yes, the answer is yes, we do.
Okay, and then next question. I would mention just when it comes to mediation. So in Texas, the benefit review conference, that's akin to a mediation. The benefit review officer is an agency employee. I know in some jurisdictions the mediator may be a private mediator, but that's not how it is in Texas. Okay, and if I skip over your question, maybe we may need a little more time to answer it meaningfully. Next question: can the insurance carrier request that a disputed issue proceed directly to a contested case hearing after the first benefit review conference when there is no chance of the issue being resolved? For example, a denied claim. Anyone want to take that? I think it may be related to the next question, which is why would an employee want to go straight to a contested case hearing instead of having a benefit review conference? A lot of that may have to do with it just, mediation may not be fruitful. It may be that really it's a question, maybe a legal question that needs to be decided by a judge. Anyone want to add anything, Director Carruthers or Director Thomas?
I don't think I have anything to add. Nope.
All right. So what happens if you have a benefit review conference, but between the benefit review conference and your scheduled contested case hearing, a new issue comes up?
I can take that.
Okay, go ahead.
All right, so if a new issue comes up and it wasn't discussed at a benefit review conference, you can file a response to the BRC report and request to add the issue. But a lot of times going back and having a BRC, if it's a completely different issue, would be fruitful. So it just depends on the situation. If it's a completely new issue related to that exact WIC number, then you can request the judge to add that issue. A lot of times the judge will request a pre-hearing conference just to try to sort it out, because you really do not want to blindside the other party. Everybody needs to walk into the contested case hearing on even footing. That's why there's a benefit review conference report that outlines those issues.
Right. And then one of the really good question, what are the most common disputes you see in workers' compensation cases and what usually triggers them? I can tell you, yeah, we had a slide about that, but so basically the most common issues we see are this extent of injury, maximum medical improvement, and impairment rating. Typically those three issues in a dispute. And really the reason that you see that is because there's longstanding legal precedent that extent of injury is a threshold issue to those two issues, maximum medical improvement and impairment rating, and that the answer to maximum medical improvement and impairment rating that naturally flows from the resolution of the extent of injury issue. And oftentimes I believe that with extent of injury, and Director Thomas, Director Carruthers, correct me if I'm wrong, but I think a lot of that comes from the denial of treatment for a certain condition. Perhaps there's a denial by the insurance carrier of compensability of that condition, and then that tends to lead to dispute resolution.
Yeah, and another trigger would be the issuance of the first certification of MMI and impairment rating. So if such a certification is issued, then as was mentioned during the presentation, then there is that deadline to contest that first certification of maximum medical improvement and assign them an impairment rating, and then that's what gets into dispute resolution. And usually, and most oftentimes, there'll be an extent of injury issue identified when that dispute is mediated.
Right. Another excellent question. I say they're all excellent questions, and I'm afraid we're not going to have time to get through all of them. But the next one: what is the standard that benefit review officers use to evaluate evidence? The same as a court with rules of evidence. Excellent question. So in Texas, disputes in the workers' compensation administrative law system, they are not bound by the rules of evidence or civil procedure. And essentially, the administrative law judge is going to weigh the evidence. And typically, the standard is like, the party with the burden of proof has the burden by a preponderance of the evidence. And the rules of evidence do not apply. And there was a question, I guess, about what standard do the benefit review officers use to evaluate the evidence. the benefit review officer really doesn't evaluate the evidence. The benefit review officer really is in the position of mediating the dispute to see if resolution can be reached. The administrative law judge will evaluate the evidence, but anyhow, I hope I answered that question. Director Carruthers, Director Thomas, did you have anything to add to that?
No, that was great. Thank you.
No, I think you covered everything.
Okay, and then if a designated doctor has been previously appointed to address extent of injury, not maximum medical improvement or impairment rating, can the first certification of maximum medical improvement and impairment rating by someone other than a designated doctor be disputed simply by DWC 32 requesting a designated doctor, or does a DWIC 45 need to be filed? And my understanding is that it would need to be a designated doctor appointed to determine maximum medical improvement and impairment rating. I believe there are appeals panel decisions on that, because if you don't have a designated doctor on maximum medical improvement and impairment rating, I mean, finality is about maximum medical improvement and impairment rating. So that's a key question there. So I hope I answered that. Director Thomas, Director Carruthers, anything to add to that?
No, that was spot on. Thank you.
Nothing for me. Although an attorney you never know what could come up in dispute. And you may have an attorney saying, well, let's just do both a 32 and a 45 just to be safe, just in case. So, but I think everything the information provided was spot on.
As always, there are disclaimers to everything that we say. So, all right. And then let's see, what rights might an employee have if they are terminated in the middle of an appeal? That's a little bit outside of the bounds, I guess, of what we deal with in dispute resolution. But I believe that it's Chapter 415 of the Labor Code deals with retaliation, causes of action in Texas. So that may be something that you want to look into, but that's outside of the jurisdiction of DWC dispute resolution. That would be a court. That would go to court. So, all right, we have time for one more question. Okay. In deciding a contested case hearing decision, can a hearing officer ignore a previous DWC 24 agreements? Oh, I mean, that I don't want to do that. It depends, but yeah, I'll go Director Carruthers.
Yeah, I would say that if there's a DWIC 24, I believe the rules say that agreement is binding through the resolution of any disputes, unless there are some rules that allow parties to come in and challenge a previously approved agreement. But I believe until something like that happens, it's binding on the parties.
And I'm going to add just a little bit. It has to be on those exact issues. If it's a 24 unrelated to what they're adjudicating, I would just keep that in mind.
Right.
All right. Well, thank you for joining us today. And I apologize. We didn't get to all of your questions. I'm going to leave my contact information in case we didn't get to your question and you'd like to follow up with me. My email address is Jennifer, JENNIFER.Hopens, HOPENS @TDI.texas.gov, Gov. It's been a pleasure speaking with you today. And after the webinar ends, please take the short survey that pops up to help us make these webinars the best we can. And I hope you all have a great day. Thank you.